Welcome to Behind the Case podcast, a podcast that focuses on navigating the challenges our clients face with divorce and family law in Dallas, Fort Worth, Texas. Behind the Case is brought to you by the Turner Monahan legal team. With over 70 years of collective experience in divorce and family law. Together, Tyler Monahan, Keaton Monahan, Tina Campbell, and the Turner Monahan team will discuss real-life cases, answer questions, and explore family law areas from divorce to child custody. Our goal is to clarify scenarios and demystify legal jargon, making the process less daunting and reminding you that you're not alone. So sit back and let's discuss what happens behind the case.
If a spouse gives me a car or a house as a gift, does that become mine alone under Texas law?
Well, a lot of people wonder about gifts and how those things work in a divorce. And for the most part, if a gift is provided to a spouse, let's say it's a ring or a watch or jewelry or maybe even a painting or something like that, a lot of times people assert that's a gift. And many times the courts look at those and view those as gifts. Now, if you're talking about a car or a house or an airplane or a boat or something of that nature, more than likely the court is going to look at it as part of the community estate and not necessarily a gift, unless there is some sort of written statement or intent that can be shown where the full intent was that for that to not be part of the community, for it to be an absolute gift, and that there's no way that they would ever state that it would be community property. Do you agree with that?
I do, and it's extremely rare that there's that kind of documentation to show such a large asset being a direct gift that is meant to be somebody's sole and separate property. So a lot of it also comes down to where did the funds come from to purchase this item. So if you're currently married and your spouse purchased you a car, most likely it's community assets being used to purchase this particular asset. So the court would kind of trace that back and say, we're probably going to divide that.
What actually counts as a gift and how can you prove it?
Well, as I said earlier, what counts as a gift is an interpretation from the court. But what we have seen is that when people are asserting that certain jewelry is a gift, like a wedding ring or an engagement ring or some sort of 10th, 15th, 20th wedding anniversary, sometimes even artwork, things of that nature, where it can be shown that, hey, I got this at Christmas and it says it's a gift, that's a different circumstance. It just generally large ticket items, houses and boats and cars and trucks and stuff are not considered gifts from the perspective of this is mine. It should not be included in the community estate for value. It's all mine on my separate property.
Agreed.
Can a spouse ever take back a gift?
There's really no such thing as taking back a gift. So, I mean, it happens in almost every divorce where somebody says, no, that wasn't a gift. I didn't give that to them. I didn't want them to wear around that ring. I was actually letting them borrow that ring. And then I was actually going to take it back. I mean, you can state that it wasn't a gift, but it's, again, will depend upon the circumstances and the item that is trying to be ungifted.
Absolutely. And a court will look at that to make determinations. And if you all of a sudden, if a client all of a sudden says every single thing that I've ever purchased was never, ever a gift and I want all of that back, then a court's going to take that into consideration and maybe think that there's some ill intent there.
And I think it's important that the point that we're making also is that, when you come and visit with our attorneys, we're going to let you know what we believe is the truth and what we think a court would do. There are maybe some attorneys out there who are going to tell you what you want to hear, that the house that was allegedly that was gifted to this person or done this way or done that way, we tell you what you want to hear, so you're going to retain us. We're not going to do that. We're going to make sure that we tell you what we believe is our opinion, that based upon the current family code and what we've seen in our years of experience with courts, and not only courts, with maybe mediations, et cetera, of how things have been divided and what makes the most sense.
All right. I know we've talked a couple of times about the ring, so the engagement ring. Whose is it in a divorce?
Well, I mean, as stated, generally jewelry, engagement rings, wedding rings, anniversary gifts, things that were provided as gifts that are generally worn as jewelry, those things are gifts. Now, If both persons are wearing the engagement ring, I guess then they can argue about that. We don't see that often. Usually both parties have their own separate rings. Watches are generally the same way. Usually the two parties don't wear the same watch. They may have gifted or exchanged watches, or maybe one party bought the other party a watch. It could be a $25,000 watch. That doesn't mean in and of itself that it's not a gift, but that's something, again, that the court would have to take into consideration at the time of determining what's a gift and what isn't.
Agreed. And I mean, there's lots of case law and lots of opinions written by courts about wedding rings and engagement rings really are considered a gift to the person who's wearing them. So typically, pretty consistently, we say wedding rings belong to the person who has it.
What about like large sums of money that come from family members as a gift to maybe help you through a tough time or things like that, and you still have some of that money? Is that money as a gift the individual child from that parent potentially?
Let's take a quick pause here. If you or someone you know is navigating divorce or family law matters in the Dallas-Fort Worth area, reach out to Turner Monahan for a free legal consultation. Call us at 817-332-4477 or visit us at tumolaw.com. That's TUMOLAW.com for a free legal consultation. Now, let's get back to behind the case.
Part of it's going to be determined about if there was anything in writing. But typically, if there's cash received, it's going to be considered community unless there was something in writing that says this is a direct gift to this particular individual for this sole and separate purpose. Documentation is kind of always the important part. And if there's not documentation, you need to recognize that it then comes to the judge to make a determination as to what they believe is appropriate in regards to that.
Unless you're able to reach some sort of agreement in mediation, because every single court that we're in front of, for the most part, is going to order to go to mediation before a trial.
How do digital assets like cryptocurrency, NFTs, how do they fit into the law if they're considered gifts?
NFTs, cryptocurrency, anything that is what most people call an obscure investment vehicle, those things are treated no different than an IRA or a 401k or stocks or bonds or anything of that nature. It may be more difficult to determine the value. It may not be as readily ascertainable, meaning like the Dow Jones or the S&P or the NASDAQ. But generally, for the most part, those type of investments now have an ability to either you're able to go to a direct source to figure out what the value is, or you can bring in an evaluator to determine what the value may be of whatever investment it is. And they're handled no different than any other investment.
Correct. I mean, there may be different mechanisms for transferring those funds. It may be that instead of transferring part of the crypto, you get a value, you get dollars instead, but they are divided and dealt with in the exact same way as any other type of investment account.
Correct.
Could giving a gift cause unexpected problems in the divorce or in the property division?
I mean, I don't think there's anything that would pose a problem in providing a gift. Now, if you're providing gifts outside of the marriage, then yes, then that could be an issue. Providing gifts to people that are third parties that maybe your spouse had no idea that you're providing it to them, especially if it's a paramour or something, that could pose an issue. But as far as just a gift and providing that to the other party, quote unquote, posing an issue in a divorce, no. It'd have to be raised. And I guess if one party wants to fight with the other party of it not being a gift or it being a gift, then that could be an issue. But again, that would be for the trier of fact to determine or to get it settled in mediation.
Yeah, absolutely agreed.
Is this something you would want to add to your prenuptial agreements, anything around gifts?
I would say yes. I mean, if there's any concern or you're in a financial position where these types of large assets would be gifted, then yes, you want to protect yourself as much as possible. And if you're going to the extreme of going ahead and doing a prenuptial agreement, there's no reason to not add provisions dealing with future gifts.
Right. And inside of a premarital agreement, you can also state in there specifically on how a gift could be determined, meaning the intent of the parties, or if it was just titled in their specific name, or if they were the only ones using it and only benefited from it. You can also do the same thing in a post-nuptial agreement and even in a partition exchange agreement.
If someone is about to get divorced and they're like, I have this large gift that was given to me, I want to make sure I protect it, what do they do? Who do they reach out to? And what does that process look like?
Number one, when we're talking about gifts, it's going to depend upon how the gift was acquired. If the gift was acquired by outside third party, like a family member, an aunt, uncle, a parent, or grandparent, that's a totally different situation than a gift that would come from a spouse. So, and it would also depend upon what type of gift. But if there is a outside third party who is a grandparent or a parent or an aunt or an uncle who provides a gift to a spouse, that is generally considered their separate property. It's a rebuttable presumption. Everything's community, but then you can rebut the presumption of it being community by saying, look, I acquired this through either somebody passing away or a gift directly from my family member, and be able to show that that's separate property. Gifts between spouses, again, is going to come down to the type of gift that was allegedly gifted to one of the other spouses.
Yeah, and it'll be up to a judge to make a determination if there can't be an agreement reached.
And then how do they reach out to you?
The easiest way is to go to our website at www.tumolaw.com, or they're welcome to call and have a consultation with us at 817-332-4477.
Thank you for joining us on today's episode of Behind the Case. If this episode offered insight or helped clarify some aspect of divorce and family law, we encourage you to subscribe and share it with others who might benefit. For those in the DFW area that are in need of a legal consultation, you can reach us at tumolaw.com. That's TUMOLAW.com, or 817-332-4477 to schedule a free legal consultation. Remember, the journey through legal matters can be complex, but you don't have to navigate it alone. Until our next discussion, take care. Please note that the information provided in this podcast is for educational purposes only and is not intended as legal advice. Listening to this podcast or contacting our team does not constitute an attorney-client relationship. For advice on your specific situation, please consult with a licensed attorney in your area.